Following the first series of our video on the upcoming enforcement of the Thailand's Personal Data Protection Act, also known as the PDPA, as well as the type of legal basis to which businesses can rely upon to legally collect and process personal data, it is also important for us to bring to your attention to another key item, which is on the appointment of the Data Protection Officer, also known as the DPO. Similar to the European Union's General Data Protection Regulation, the Thai PDPA also requires business organizations to appoint a DPO if their business activities requires regular and systemic monitoring of personal data as the result of processing large volume of personal data as well as sensitive personal data. Essentially, the duties of DPO is not an operational one, but it involves giving advice to and monitoring the compliance by the business organization, including their employees, towards the PDPA provisions. Such duties must be performed in an autonomous and independent manner. In other words, the business organization must not instruct nor influence the DPO's performance of services, and that he or she must be allowed to operate without being put into a conflict of interest situation. For example, an individual who holds operational and senior management roles in a company that determines the purposes and means of processing data, he or she must not be appointed as an internal DPO. So this leads us to the question of whether the DPO should be appointed internally within an organization, or should such role be outsourced to a third-party service provider. The Thai PDPA does not lay out any restriction in this respect. Both methods work. Based on our advisory experiences, many companies consider outsourcing as a fairly practical option because there is a lot of training and education required when it comes to internal appointment of a candidate, while the data privacy service provider, on the other hand, they are independent organizations, so the likelihood of a conflict of interest arises between the outsourced DPOs and the organization unit remains rather low. In considering whether to make an internal appointment or go with the outsourcing route, the business organization may need to consider a number of substantial factors, such as the size and nature of the organization, in particular the budget allocated for the appointment of the DPO, the staffs and resources available who could take on a DPO role, and most importantly, whether he or she is able to take on such role in line with the PDPA to keep not only his or her duties, but as well as the company activities in line with the data protection laws, so as to not lean towards the conflict of interest situation. So whether the decision is made to appoint a staff member or an outsourced contractor as DPO, this position within the organization will remain of great importance, especially with the upcoming enforcement of the Thai PDPA and with stories of heavy fines start appearing on newspaper headlines. The role of the DPO within any organization will be expected to take on great significance when it becomes clear that they in fact act as a first-line defender or an early warning provider from the local enforcement authority. So in short, this is an important appointment, and a good deal of time and consideration should go into choosing the right person for such role and making sure that he or she will be able to perform the duties in line with the PDPA in a way that will not compromise his or her ability to do so.